Hello everyone, my name is Danielle and in today's video we're going to be having a look at some legal writing exercises. These are very basic legal scenarios and here we are learning how to identify the key facts and relevant law. The second case scenario that we're going to look at today, we will also then be going through how to use IRAC to respond and how we would set out a legal memo if required in an assignment. So this is our first case scenario. So we have ABC Construction, a large construction company in Australia, has been awarded a contract to build a new office complex for XYZ Corp, a multinational corporation. During the construction process, ABC Construction discovers that there is a significant amount of contaminated soil on the construction site, which will require additional time and expense to remove before construction can continue. XYZ Corp argues that ABC should have known about the contaminated soil before bidding on the project and therefore should bear the additional costs and delays. ABC Construction argues that the presence of the contaminated soil was not disclosed in the bidding documents and that they should be compensated for the extra work and expense. So the first thing we're going to look at in any problem question that we are given in an assignment or an exam is what are the key facts. Then we're going to look at what potential sources of law could be used to resolve this dispute. Now, keeping in mind, this is a very brief legal scenario, so most of the facts are key facts. However, as you progress through your legal studies, you will come across scenarios which might be longer. So there might be an A4 page of text. Therefore, you need to be able to discern what's a key fact and what is just fluff or additional information which has been added by your lecturer into the scenario. So I would give yourself about 5 minutes maximum, go through this scenario and jot down all of the key facts. And in your brain, also be thinking about why are they relevant? What am I hoping to achieve from this? So feel free to pause. And then we're going to go through the answers now. So first and foremost, it's always important to start off with who are the key parties. So here we have ABC Construction and XYZ Corporation. Now in a longer case scenario, there might be 4 or 5 parties. However, some of them may be irrelevant for the purposes of your scenario. This case scenario doesn't come with a question. However, in an assignment or an exam question, your lecturer might ask you something like, advise ABC Construction, or XYZ Corporation has come to you for legal advice regarding remedies. And that will give you a hint as to who you are providing legal advice to. They are obviously your first and foremost key party. However, then you need to look at who else has impacted that party and who else has conducted themselves in a manner as to either advantage or disadvantage your client. The next thing we're going to look at is initial timing of the dispute. So again, this is a very basic case scenario. However, in some of the longer ones that we've looked at, particularly with some of the examples that we already have up here on our videos, there will be a timing or a timeline that you need to take into consideration for any dispute. And like I show you in one of the other videos, it's a good idea to get a timeline going on either your piece of scrap paper or in a Word document so that you are very clear on the process. Then we're going to look at, well, what happened to cause this dispute or what happened to cause the issue? So here we know that ABC Construction discovers contaminated soil. So we have a latent condition. This is the issue or what has happened to cause the case scenario. If this hadn't happened, there would probably be no dispute and this wouldn't be a scenario that you were looking at. Then we're going to have an impact to the build. So obviously if either party needs damages, there has to be some sort of impact or detriment to the party. And here we know that this contaminated soil is going to require additional time and expense to remove before construction can continue. So we know that that means that there will be a potential delay to the critical timeline. There will be a monetary impact to the project, and also it might require additional resources which they hadn't factored in. then it's always a good idea to look at what the different parties are arguing. XYZ here is arguing that ABC should have known about the contaminated soil before bidding on the project, and therefore ABC should bear the additional costs and delays. So if you were providing legal advice to XYZ, you would then be looking for ways to justify, and then also some counter arguments, because it's always a good idea to think about what the other party will come back with, about why ABC should bear the additional costs and delays. ABC, on the other hand, is arguing that this contaminated soil was not disclosed and therefore they should be compensated. So the real crux of the issue here is who is going to bear the brunt for the extra work and the extra expense and the delays. And that is the key issue and the arguments for and against. So now that we know the key facts, we're going to have a look and think, well, what potential sources of law could be used to resolve this dispute? Keeping in mind, in your contracts course, you will have multiple types of contract disputes. In an environmental law course, you would have multiple types of environmental law. So it's important to look at what has your lecturer taught you to date, go through the topics for each week, and then have a look at what those topics line up with in terms of what potential sources of law could be used. And here we have some basics. So we have contract law, we have tort law, environmental law, and of course, common law. Like I said, though, you would need to have a look at what topic you are looking at and what your lecturer has taught you to date, because that is what they are assessing you on. So if your lecturer has not discussed environmental law to date, this would not be the avenue that you pursue. If it's a tort law course, you would be pursuing tort law remedies. If it's a contracts law course, you would be pursuing contract law remedies. And of course, the common law underpins all of these, so they would be used throughout. So the next legal writing exercise we are going to undertake is identifying the key facts of a case scenario and using IRAC to compile a legal memo. So this is our example. We have Matthew, a 50-year-old independent contractor from Victoria, has been engaged for some work by XPTY Ltd. Matthew attends a number of staff meetings as well as a training course provided by the company. Matthew comes to you for advice about whether he would be considered an employee of the company, which would mean certain rights and obligations are conferred on him. And what we've been asked to do today is to write a formal legal memo to Matthew, who is our client, advising him on the above situation. And I would like to say thank you to Monash University for this legal memo example. So the first question, if we were providing legal advice, how would we structure this? And of course, we are going to use IRAC. In our ICA course, we look at this in week 3. So this is issue, rule, application, and conclusion. So first, we are going to identify the relevant facts. So again, get the highlighter out, get your scrap piece of paper out, take note. Who are we looking at? Why are we looking at them? And a tip here is to think the who, what, where, when, and how. It's also important to think, well, is there any missing information? Because missing information means that you would need to be making assumptions, and those assumptions need to be detailed. So if you are making assumptions in your responses in either your assignment or your exam, you need to let the marker know what those assumptions are so that they understand how you've reached the conclusion you've come across. So here are the relevant facts. We have Matthew is an independent contractor. He has an employment contract with company XPTY Ltd. He has attended some company staff meetings and a training course. We should note the jurisdiction of Victoria may be relevant here, and it is unlikely that Matthew's age would be a relevant factor. So then we're going to look at the issues. So what's the key issue? And it's important to note an assignment usually covers one area of law, but may involve a number of issues within that area. And again, refer to your class notes and your reading guide. We're going to use IRAC to structure each issue that we identify. And issues may emerge gradually as a result of your research and identification of applicable rules. So one of the legal issues in this scenario is whether Matthew is an employee of the company or working for them as an independent contractor. So now we're going to look for and state the rules. So this is the rules in IRAC. When providing legal advice, we don't make things up based on what we think should be the outcome. We need rules to justify that conclusion. So note, break down the relevant rules of law into elements. Each element is a sub-issue to which you will need to apply IRAC reasoning. You do not always need to use the parties' names or specific facts from the entire case that you are referencing. The rule will be the definition of the principle of law applicable in the case. In longer case scenarios with more complex issues, you will need to get into the parties' names and specific facts. However, for a case scenario that's this short, you don't need to be getting into a lengthy discussion of what happened in that case. Particularly if we are looking at this legal memo, it's important to think, does my client need to know or need to understand the facts of that case? Or is it sufficient to say that in this case, this conclusion was reached? The legal principles should be stated with precision and accuracy, and we always support legal principles with authorities. So authorities, that's common law, which is your case law or your legislation. We need to make sure that we know how to research and find authorities. Often they will be mentioned in the lecture notes. Often they will be brought up in tutorials, your textbook, and your reading guide. So make sure you are working through your course content and not relying on Google to answer your questions. So a statement of the relevant rule here could be that the current common law test for determining whether a worker is an employee or an independent contractor is the multi-factor test as laid down and confirmed by Stevens against Broadrib. So see how we haven't gone into the case details of Stevens? Because we just need to know that the rule from Stevens is that there is a multi-factor test that we're going to need to work through in order to answer Matthew's question. Then we need to apply the rules to the problem. So in this situation, it would be applying that multi-factor test to Matthew's situation. Now, for more complex and lengthier case scenarios, and as you progress in your legal studies, reading the reasoning of judges in cases can actually help you understand how legal problems are analysed and applied to the specific facts of the case. So by reading judgments from the judges, it can actually help you understand how to write in a legal manner and how to argue factors for and against. We need to use legal principles and precedent in each analysis. So here we might say the company requires Matthew to attend meetings and trainings which show that they have a high level of control over him. Here we have two cases. These factors indicate that he is considered an employee, and we have another case. So here we have three authorities that we are mentioning. We have Stevens, we have Stevens, we have ACE Insurance, and we have Hollis. These are our authorities. We may have obtained these from the lecture slides or from the readings or from the tutorials, but we know that they're the relevant cases that are the authority for why we are arguing for or against Matthew. Now we are going to conclude. So we always need to be providing a conclusion in our legal advice. At the end of the day, the client has come to you for a legal solution. However, we need to remember that we are not the judge, so you cannot be definite in concluding that the courts will decide in your favour. We need to use terminology that supports the likelihood of a particular outcome. So words to use would be will likely, or can be regarded, or most likely will be regarded, or it seems it may be regarded. However, we do not want to write things like Matthew is an employee and therefore he is owed $1 million, because we don't know that that's what the courts are going to conclude. So what we might say is in our notes is XPTY Ltd exercises control over how Matthew performs his work. According to the multi-factor test confirmed in Stevens, this indicates that Matthew can be regarded as an employee while under the terms of engagement. So now we need to put our notes together into a legal memo. So we always start off with a file number or a case number. We have the recipient, we have the sender, we have a date, and we have re. So re is in regards to. Now, this one has started with a heading called summary. You may or may not include these initial headings. However, it is a good idea throughout your memo to use headings. However, whether you use these specific headings or more formal headings will be a matter for your assessment. Now, this one has started off with, "Hi, Matt, thanks for your recent call." That is too informal for a legal memo. Now, a legal memo, remember, that is going on file. It is an output to the client. An email can start with, "Hi, Matt." A legal memo should not start with, "Hi, Matt." Then we're letting them know in the executive summary what the memorandum is about and why we have sent them a legal memorandum. Then we're going on to employment status, and we are going to work through each of the issues. However, what we're not going to do is see how we've got here where it says rule as a heading. We are not going to write issue, rule, application, conclusion as our headings. We might have them there to start off with, write our paragraphs underneath, and then go back and delete the IRAC heading. IRAC is a way to structure your response. However, it is not suitable to be used as a heading as it is too informal. We need to make sure that we are always applying the law to the facts of the client's case. So here we've got, "In your situation as ex-PTY Ltd requires you to attend staff meetings and have required you to attend a training session, this indicates that the company has a degree of control over your activities in relation to the work done for the company." Then we're going to conclude with some findings and recommendations. And again, this is our overall conclusion. We're not saying it's 100% confirmed. We always say it is likely. And then we are going to sign off the memorandum with your name, and you might then add in your title or your job position. Thank you.